Hello friends, pro bono champions. I'm David Hillard, a pro bono partner at Clayton Utz in Australia. I was absolutely honoured and delighted last night when Pillnet asked me, one of Australia's least impressive lawyers, to introduce Australia's most impressive lawyer. The Honourable Justice Michael Kirby is an eminent international jurist. A Justice of the High Court of Australia from 1996 to 2009, he wrote judgments that were loved by lawyers and law students alike. If it's possible to have a rock star judge, we have one here with us today. I won't embarrass his honour by pointing out that his 12,000 Twitter followers really are pitiful in comparison to 439,000. Nor will I embarrass Todong Mulya Lubis by pointing out that his honour has never actually sent a tweet and still has 12,000 Twitter followers. His Honour has played many international roles for the United Nations, the Commonwealth Secretariat, the OECD, and leading roles in civil society organisations. He served as a President of the International Commission of Jurists, a Commissioner of the UNDP Global Commission on HIV and the Law, Chair of the UN Commission of Inquiry on North Korea, a member of the UN Secretary-General's High-Level Panel on Access to Essential Healthcare. He holds a position as Honorary Professor at 12 universities. If any of you have been wondering why you've not been asked to be an Honorary Professor, it's because they've all been taken by one man. A Companion of the Order of Australia for his services to the law and to law reform. An Australian National Living Treasure. Yes, we have titles like that in Australia. And most importantly for all of us, a strong moral voice in Australia for social justice, for public education, for pro bono, for LGBTI rights. I've been particularly delighted over the last fortnight to watch His Honour hold the Australian Parliament to its responsibility to act now for marriage equality. It is, for me, and I'm sure in a moment for you, an absolute privilege and a pleasure to welcome to the stage the Honourable Justice Michael Kirby.
Thank you very much, David. But did you have to mention the number of my followers on Twitter? Could we do a deal, my brother Lubis? You lend me, say, 80,000 of yours, and I will make my first tweet. I pay my respects to the people of Indonesia, and I thank, through them, those of our brothers and sisters from Indonesia who are here and have been our wonderful hosts in the last day and a half at this conference. It's been a splendid conference with lots of new ideas. I began my life as a young lawyer working substantially in pro bono work. And it brought me great joy and fulfilment. And that is a secret that we can share with lawyers generally. But when I became a judge, I strove very hard to act in accordance with the law and in accordance with justice. And one of the first cases that came before me on the High Court of Australia was a case involving a person who had been convicted of murder in Western Australia. And I sat with two other justices at the gateway to the hearing of a case in the court, and unanimously we refused to open the gateway. And he went and served a dozen years thereafter for a crime of murder. Later, he persuaded the Governor of Western Australia to provide an inquiry into his conviction. That led to an inquiry by the Court of Appeal in Western Australia, which refused to reopen the conviction, and he came back to the High Court of Australia. I didn't sit at the gateway on this occasion. 3 other justices opened the gate. But I was assigned to sit in the case, and as I read the papers, I thought to myself, I know this case. I've read this case. It was a very different case in the sense that pro bono lawyers of outstanding quality had agreed to take the case back to the High Court of Australia. They were, in fact, by sheer coincidence, pro bono lawyers from Clayton Utes in Western Australia, David's firm. This wasn't a plot by Clayton Utes to get a free commercial at this conference. It just happened that they did the pro bono work. They shifted the ground. The first case had been based upon the fact that though the prisoner had asked for a polygraph test, a lie detector, that is not a practice that is admissible in Australia, and therefore it wasn't unusual that the High Court on the first application should refuse to reopen the matter. But when it came back by outstanding pro bono lawyering, what they did was to take objective facts in the evidence. The fact of the time when he was discharged on another minor matter from the Perth lockup by the police, and the fact of when he was seen in a camera on a taxi leaving the taxi on the other side of the city of Perth. Putting the two together, he could not have been at the murder scene at the time that the murder was shown to have happened. And that was done by fastidious lawyering, going through every grain and ounce of the evidence and bringing it to the attention of the court. And we allowed the appeal, we set aside his conviction, and a subsequent inquiry by an independent commissioner, a judge, found that the murder had been committed by another person who actually had confessed to it in prison. And so that brought home to me both the enormous importance, if I ever doubted it, of pro bono lawyering, and also the importance of the constant, vigilant and unrelenting search for justice. And justice needs advocates. And we today are assembled here as advocates for justice, that, as my brother Lubis has said, needs pro bono lawyers. Now, I have sat through the conference, and I go to many conferences, but I've taken away 20 big ideas from this conference. If you get 3 big ideas from a conference, generally you're doing well. But I've noted down my 20 ideas. You will all have the ideas you will take away, but these are my 20 ideas. Number 1 was given to us by Garth Manches, the president of PillNet, who bring us together. He gave us the secret of pro bono lawyering. He shared it all with us in his opening remarks. The secret, he said, was lawyers, most lawyers, many lawyers, want to do pro bono lawyering. They want to do it because the thing that often attracted them to law in the very first place, when they were choosing theology or nuclear physics or merchant banking, they chose lawyering because in their minds was a quest to be involved in doing justice, sometimes, occasionally, often. And that is a secret which we can share with the rest of the world. The second big idea was given in the speech that immediately followed by my friend and long-term colleague Asma Jahangir. Asma gave us 2 big ideas. The first was very relevant to what Mr. Lubis has just said. Often, pro bono lawyering is most important where it is in the interest of an unpopular cause. And many unpopular causes Asma Jahangir has taken on, not because it will get laurels and praise, but because it's the right thing to do. The bar may itself have doubts. The populace may be absolutely opposed to what is being done. But picking up and presenting unpopular causes where their foundation is strong in law or in the facts is a vital role. And the third important idea, the second that Asma shared with us, was that pro bono lawyers can't guarantee success. The law may be all wrong. The law is quite often wrong and unfair. Or the judges may be unfavourable. They may be prejudiced against the propositions being advanced. But a great professor taught me at law school, we are not given in our lifetime as lawyers to cure every wrong, but neither are we free from the obligation to try. And therefore, the fact that it's unpopular or the fact that it may fail is not a reason not to take on a just and worthy case. The fourth big idea was actually given by the representative of the governor of Bali. You remember he came late, it may have been the traffic, but whatever the reason, he gave his talk at the end of his remarks. And he said that law can mandate justice, that laws have been enacted in Indonesia, law number 16 of 2011, to encourage and even require pro bono lawyering. And that is a good thing, but he also said, let us not discriminate against one group in the population. I thought that was a very strong message and one which has been reinforced at the beginning of our conference today and in the speech which Todong Mulya Lubis has given us at the end. Let us not discriminate against any member of the population. The sixth big idea was given by Nick Booth from UNDP. He told us that Asia is an under-lawyered region. And that was borne out when I heard how many lawyers there are in Indonesia, this mighty archipelago with so many millions of people. And the number of lawyers, I think I heard the figure was 40,000, 50,000. Well, that's less than we have in Australia. And if that is true throughout Asia, Asia still is under-lawyered, and therefore pro bono lawyers are even more precious. The seventh big idea was by Melly Dasa in the group of lawyers, and she said, lawyers have to work closer with NGOs. This was an idea that came woven through a number of the propositions. They must help to tackle the causes of injustice, not just the instances, but the causes, in order to deal with what is causing repeat cases that come before the courts. The eighth big idea was presented by Nicholas Patrick in the session of lawyers speaking of what's good for business. And he gave clear indications of why, in the case of his firm, DLA Piper, giving young lawyers of talent the opportunity to do pro bono lawyering has been shown to be a very good way to keep them in the firm. Okay, you can put forward moral and ethical arguments, But if need be, you can also reach down there for good, hard, practical arguments. It retains talent, but as he said, it's got to be inspiring. It's got to be uplifting. There's only so many constitutions of charities that you can draw and call yourself a pro bono lawyer. You've got to get your hands dirty. You've got to get down there and deal with cases that may be unpopular. The ninth big idea was brought by Sue Ann Chair. She said, many can't give legal advice in countries of Asia. If they're in big international firms, they can't give advice as practitioners of law, though they may be lawyers. That there is an element of a closed shop, and we're experts in that in Australia. Closed legal markets need to open up, and part of the effort of pro bono lawyers and PILNet must be to try to persuade a growing opening of the legal market. The 10th big idea was by Tongi Lim. He pointed out that it was important that professional organisations should be supportive of pro bono lawyering. And he acknowledged how in Singapore, one particular way that has been used has been to encourage it by the recognition that's given of senior status in the legal profession. The SCs, the senior counsel, acknowledging and celebrating and honouring the lawyers who do pro bono lawyering is a good way, because lawyers like to be respected in their clan. The 11th big idea was by John Corker. I went to a session on any lessons or any experience that Australia has had that may be useful. John is in charge of the Australian Pro Bono Centre, and he pointed out, in answer to those who say pro bono lawyering makes it look as if more is being done for justice, governments must bear the greatest responsibility and provide it from the budgets. But just the same, he said, a lot can be done by a small number of dedicated lawyers acting in good and well-chosen causes. The 12th idea was actually presented by David Hillard in the same session, and that was that one of the impediments to pro bono lawyering was the impediment of suggested conflict of interest and duty. If you've got big clients, say banking clients, then it may be difficult, or thought difficult, that you take on pro bono lawyering that will challenge the client. Is that in the interest of the partnership? Is that in the interest of the firm? Well, by immunising those who are performing the pro bono lawyering, there are ways increasingly accepted by which firms can, without any fear of financial retaliation, undertake pro bono lawyering. And David pointed out that he'd never heard one of the commercial clients ever complain about the pro bono lawyering that his large firm does. The 13th big idea was presented in the same session by Fiona Macleay. Pro bono lawyering can sometimes, she said, attract retired judges. My ears pricked up at this moment. It can attract them in order to give a face to the effort and to add gravitas to the effort. And I thought, that's a very good career move for a retired judge, and more of them should do it. But she admitted, and this was something we had discussed, it's easy in a way to be bold and to be courageous in taking on this case or that, but it's not so easy to be brave. And Asma Jahangir, anyone who's been reading The Economist lately and knows about the sufferings in the Pakistan bar will know it takes courage, brave courage, to do the sort of pro bono lawyering that ASMO has done. The 15th big point was actually raised in one of the sessions by a colleague from Korea, Republic of Korea. And he asked, how come in America and in Australia and New Zealand and other places it is attractive to take on LGBT issues in the courts? And he said the answer he had been given was because it's cool. It's cool to do it. It's modern to do it. It's just to do it. It's right to do it. It's sometimes law respecting and upholding to do it, but it's not something you have to be particularly brave or even bold to do. The 16th point was raised by a Chinese colleague. How can you be brave when lawyers you know sometimes disappear? They're arrested. They're in prison, as we meet here. And this, I think, was a message that we should take away from Bali: solidarity, standing with, courageous affirmation of those who are brave and who do take brave action in protection of the rule of law. The 17th important idea came to me from Ahmad Fikri and also from Edwina Topping in a session, a wonderful session of Indonesian lawyers explaining what has been happening in Indonesia. She said, and this is something that I've heard before in Australia, that it's important for good lawyers, for good pro bono lawyers, first to be good lawyers, and that therefore those who cut their teeth on corporation law and find the ways of how to be a really good technical lawyer can often do the human rights law better than others. I found as a judge, sometimes in a human rights type case, you would get people whose utter heart and soul was in the case, but they didn't really have the skill to present the case as well as it should have been presented. And that's why you need lawyers of great ability and great experience, and they should give leads to the lawyers who are coming along. And Ahmad made the point, it's not a bad thing to be a bit boring as a pro bono lawyer. Sometimes a boring commercial lawyer can actually have the skills, when turned to advantage, to do a really good pro bono case, and to do it with appearance and reality of neutrality. There were some tremendous contributions, many big ideas in that session. Some of them from Sugeng Santoso, from Rivai, from Alvin, from Wayan Purvita. These were Indonesian pro bono lawyers, and this is what they taught me: the importance of remembering, as my brother Lubis has reminded us, of the foundation fighters for the independence of this country, Indonesia. As it was put, they didn't think, as they advanced the principles of law and of human rights, that they were running up billable hours. They were not people who were ruled by billable hours. They were ruled by some important principles. That they could find strength in unity, and that it was important to ensure the maintenance of pro bono, and if possible in a united effort of the representative organisations of Indonesia. And we had a remarkable event, Todung, that I can mention to you, when 3 of the bar associations of Indonesia actually committed themselves to strive to meet anywhere, anytime, to talk about how they could get their act together, because division is weakness, unity will be strength. And as a sign of this, they took the pro bono T-shirts that were presented to them, and each of them put the T-shirt on, and I have a photograph of them all committed to the principles of pro bono on my camera with their T-shirts, and we're going to hold them. I might even tweet about that. The 19th big idea was from Cecilia Flores de Banda. She had been, you remember, imprisoned. She actually was imprisoned for 4 years, and with her husband, her father, and her children in the time of the Marcos rule in the Philippines. But she stressed, as others had done, the vital importance of working closely with NGOs, because lawyers have good training in analysis of what problems are and in ways to solve the problem. Lawyers are problem solvers. And the 20th big idea came from my friend and colleague of many years, Vitit Munterborn. He started by telling us how his pro bono life began by him getting on a bicycle and launching out on his bicycle to change the world. Well, he certainly contributed to that. He's given back for the privileges, and his lesson to us is give back. We are the privileged ones. We are the fortunate ones who have the good fortune of our training and our education to help others, and we should give back. It's a message to lawyers everywhere, and to pro bono lawyers in particular. The message should not be, go to law school, become a lawyer and get a second car. The message should be, go to law school, become a lawyer, and remember your cause is fundamentally a cause of justice under the law. So they're my 20 big messages that down the back of the plane tonight, as I go down back to Sydney, 6.5 hours, they'll be tossing around in my brain. But there's one extra bonus. This is like frequent flyer point that you're getting. I was introduced during one of our wonderful networking sessions to a lawyer who didn't speak at our conference, but who is a lawyer to be watched because he's a lawyer of the future, Mr. Hla Ko. He's from Burma, Myanmar, and he has come to conferences on pro bono lawyering. He came to this one, he went to an earlier one, and at the earlier one, he had a Damascus Road epiphany. And he said he was never again going to take a fee-paying client. He was converted. He was only going to do pro bono lawyering. He's a young man in his early 70s, but he has found that his birthdays go in reverse order now, ever since he started doing pro bono lawyering. So that is a lesson for everyone in the room, and it's a lesson for me. If we can bottle it and sell it, it will make millions. But the best thing about this conference was a very Indonesian thing. I'm sure we've all noticed it. Everyone at the conference, or many of the speakers, have spoken about hard issues. They haven't gilded the lily. They've dealt with hard issues, which you would expect. We've had sessions on oppressive labour and migrants. In my work on North Korea, I know that that is a terrible oppression of people who are just bundled together and virtual slaves for years. And there have been such cases here. Trafficking of human beings, there have been sessions on that. The religious minorities, mentioned by others, and by Todung Lubis, the religious minorities, the cruelty that some of them have suffered. Papua, a representative of Papua stood in this room and raised the issue of Papua, and he was not stopped. Nobody rushed in to arrest him. Nobody tried to suppress his expression of his view, and those on the stage expressed some understanding of it and encouraged correspondents to follow it up. That's a very good thing. But the issue that I was listening most closely to, the issue which is one that touches my heart and my human experience, also came up. It came up in the marvellous address by Todung Mulya Lubis. It came up earlier in a number of the addresses. It concerned the LGBTIQ minority. I say it was close to my heart because it is important for me to tell you, those who don't know, that I myself am gay. I've been gay all my life since 11. And I have had a partner who telephoned me here in Bali this morning just to check up on me for 47 years. It has been important for my public life. It has been important for my personal life. It has been important for my mental health, which Mr. Lubis also mentioned. Mental health. It's been important for my physical health. Gay people, until now, have conspired with others to hate them and dislike them by silence. You can't blame straight people for disliking gays when they keep quiet as to who they are. The way to answer it is the way in Australia, as best we can, we have answered our racial demons. It is by meeting people, by meeting Asian Australians, by meeting African Australians, by meeting people and finding the commonalities of humanity that we share with them. And that is also true of LGBTIQ minority. And that's why it's important for me to explain why this is a significant issue for me. And so to Mr. Lubis and to those who raised this matter, as a human being, not as a judge, not as a lawyer, just as a human being, I thank you for raising it. I thank you for emphasising its importance. I thank you for stressing that it's basically founded in an understanding of scientific truth, that there is this smallish number of people who are gay. They're not going to just disappear. They're not going to disappear or suddenly become straight. They are your brothers and sisters, and they must be loved too. So, I think this has been a marvellous conference. It's touched upon things existential, it's touched upon things of justice and therefore of the spirit. Justice does need advocates, and we who are here in Bali commit ourselves. We will occasionally be boring, but that is the nature of a lot of law. We will often be bold, because that is the nature of pro bono lawyering. And occasionally we commit ourselves to be brave.